Yeah, good afternoon. Today we shall be doing, for the purpose of Rajasthan Judicial Services examination, the Indian Partnership Act. The Indian Partnership Act of 1932. Fine. Is the voice clear? Write in the chat box. Yeah. I hope the voice is clear. Good. The Indian Partnership Act. Before this act was legislated, the rules regarding partnership was contained in some other act. Which was that act? Indian Contract Act. Good. So we had chapter 11 of the Indian Contract Act, sections 239 to 266, which dealt with the rules regarding partnership. Fine. But those provisions were more general in nature and they were not sufficient to meet the needs of the rights and liabilities of partners and each and every minute things. Fine. Therefore, a new act was legislated in 1932, which is the Indian Partnership Act, and it came into force on which date? Any idea? It came into force on 1st October 1932, except one provision, that is section 69, effect of non-registration of firms, which came into force on 1st October 1933, 1 year after the commencement of the whole act. Fine. So this Indian Partnership Act consists of 8 chapters. This act consists of 8 chapters, which has 74 sections and 1 schedule. Fine. The schedule deals with the fee. Fine. So let's come to Indian Partnership Act now. This is an act to define and amend the law relating to partnership. Is this an exhaustive act? This is not an exhaustive act. Fine. The rules regarding partnership are contained in other acts also. Fine. There is one formula to check whether the act is exhaustive or not. If the preamble uses the word consolidate, it is to bring together, then that act will be an exhaustive act. Fine. This is not an exhaustive act. This is an act simply to define certain terms relating to partnership and to amend the law relating to partnership. Fine. Before going forward, let us first try to understand the basic idea behind framing of this legislation. Why was this legislation necessary? Basically, there were 2 reasons due to which this act had to be legislated. The first one was that the provisions of Indian Contract Act were more general in nature. Fine. Secondly, the purpose of partnership, the purpose of any partnership firm is to carry on the work entrusted to that partnership by the partners themselves. Fine. Now, since one person cannot do all the works himself, therefore generally the persons enter into partnership. Now, when there are more than one persons, in case of any dispute or any such thing, certain specific laws are required to be present. Fine. For that purpose, a specific law, that is the Indian Partnership Act, was legislated. Fine. Though this Indian Partnership Act is more or less on a whole governed by the laws of contract only. See, there is something called as Indian Contract Act, there is something called as law of contract. Fine. Law of contract is the law of the parties, It is the law of promisage between the parties. Fine. The Contract Act simply has certain rules regarding the law of contract. Fine. So this partnership is also a law of contract. This partnership is also a law of promisage between the partners that they shall be fulfilling their obligations, they shall be performing their duties mutually and with good faith and care and attention. Fine. So this Partnership Act, this Indian Partnership Act, was legislated in 1932 so that the rules regarding partnership can be given in one particular act, and in case of any dispute, this act can be have recourse to. Fine. Now, come to the Bare Act. Again, for the purpose of RJS, the questions are asked, though this subject is a newly introduced subject in RJS this year, yet the questions, the pattern of questions are basically from the Bare Act, direct questions. Fine. So we need to analyze the provisions of the Act and then we need to act accordingly. Fine. Chalo. Come to the Bare Act now. Take your Bare Act, take a pen, take a copy. Keep on writing the important points. This Act, Section 1, this Act may be called the Indian Partnership Act, shall extend to the whole of India, and it shall come on date on 1st October 1932, except Section 69, which shall come into force on 1st October 1933. We have already written this. Fine. Come to now definition clause. Fine. In this Act, unless there is anything repugnant in the subject or context, see, in the definition clause, you have basically two definitions which are important for your examination. Rest I will be reading all the 5 definitions, but 2 are important for from the examination point of view. First one, act of the firm. Second one, business. An act of a firm means any act, any positive act or omission means not doing any act. By all the partners or by any partner or agent of the firm which gives rise to a right enforceable by or against the firm, which gives right to a legal right enforceable by or against the firm, it is called act of the firm. Fine. Act of the firm, again I am telling, it is any act or omission, any positive act and any omission to do any act. Omitting to do any act means not doing the act by which any partner or all the partners of the firm or the agents of the firm are to comply with it, and it gives rise to any legally enforceable right by or against the firm. Fine. If any person, for example, if any in fact partner does any fraudulent act, then he is to be held liable to the other partners of the firm. Fine. So his act gives right to any right enforceable by the firm against him, isn't it? So this is act of the firm. Coming to business. Business, if you remember, Article 19(1)(g) of Constitution of India, it is similar to this one. Business includes every trade, occupation or profession. It is similar, not same, similar. Fine. These two definitions, 2A and 2B, try to remember. Fine. Prescribed means prescribed by rules. You do not need to remember this. Third party used in relation to the firm or to partner therein means any person who is not a partner in the firm, means any outsider. Fine. And expressions used but not defined in this act. Pari materia. On the same footing. And defined in the Indian Contract Act 1872, 9 of 1872, shall have the meanings assigned to them in that act. Means any term which you do not find here, but you find in Indian Contract Act. Like, you have one term you will come across, fraud by the partners. So fraud has not been defined here, but fraud has been dealt under Indian Contract Act. Fine. When you see section 17, fraud, if any contract is vitiated by fraud, that contract is voidable at the option of the party on whom fraud was committed. Fine. So you need to take the meaning of fraud from that act, Indian Contract Act. That is what section 2 clause E states. Fine. Application of provisions of Act 9 of 1872, that is application of provisions of Indian Contract Act, the unrepealed provisions of Indian Contract Act, save in so far as they are inconsistent with the express provisions of this Act, shall continue to apply to the firms. Fine. Come to the important section, that is, from the definition point of view, section 4. Section 4. Definition of partnership, partner, firm and firm name. What is a partnership? What is a partnership? Partnership is a relationship, is a relation between persons, between two or more persons. One person cannot form a partnership with himself. Fine. He needs to be partner with someone else. He needs to be associated with someone else. Fine. Therefore, partnership is the relation between persons who have agreed to share the profits, of business carried on by all or any of them acting for all. Again I am reading, partnership is the relation between persons, between two or more persons. Keep on writing. Who have agreed to share the profits and losses generally. The word generally is being used here because once you read section 30, minor, so minor can be admitted to the benefits of the partnership only. Fine. Share the profits and losses generally of a business carried on by all the partners, or by any of them acting for all, acting on behalf of all. Try to understand this. This partnership, देखो, section 4, 5 and 6, these three are the most important sections as far as I consider. Fine. The whole partnership is based on these 4, 5 and 6. Sections 4, 5 and 6. Fine. Come to 4 again. Partnership is the relation between persons who have agreed to share the profits. Relation between persons, in fact, just 1 minute. Relation between persons who have agreed to share profits, including losses generally. Fine. Relations between persons who have agreed to share profits, including losses generally, of a business carried on by all or any of them acting for all. Profits of a business carried on by all the partners or by any one or more on behalf of all. यही है ना, सेक्शन 4 का फर्स्ट पैराग्राफ तो यही है ना. पार्टनरशिप क्या होता है? पार्टनरशिप एक रिलेशन है. ये रिलेशन कैसे एग्जिस्टेंस में आता है? ये रिलेशन, अभी आप 5 देखेंगे, ये रिलेशन कॉन्ट्रैक्ट से एग्जिस्टेंस में आता है. रिलेशन बाय कॉन्ट्रैक्ट. करेक्ट? Between persons. What kind of persons? Can be natural or legal persons. Fine. Sharing of profits. Monetary benefits generally, and losses. Fine. Of business, this is any trade, occupation or commerce. By all the partners or by any one or more on behalf of all. That is, by partners of firm or any one partner on behalf of all, because these partners need to act mutually. Fine. There shall be consensus ad idem. कॉन्ट्रैक्ट याद करो. फाइन, समझ रहे हैं? फाइन. All those who are online, they may even comment in the chat box. Fine. I hope you guys are understanding. Now, this is partnership. यहाँ पे हमने persons में लिखा natural or legal persons. Now, one question arises that can one partnership be a partner in another partnership firm? Fine. So partnership is not a legal entity like a company. Fine. So one partnership cannot be a partner in some other partnership firm. Fine. Remember this. Again, Hindu undivided family. What is this Hindu undivided family? This Hindu undivided family is created by status, not by contract. मान लो मैं हूँ, मेरे फादर हैं, मेरे अंकल हैं, मेरे ब्रदर्स हैं, सिस्टर्स हैं, मदर हैं, everyone is there. So if we are doing any business, हमारे बीच में कोई कॉन्ट्रैक्ट नहीं है ना, और हम लोग कॉन्ट्रैक्ट से नहीं बने हैं ना. वी आर देयर बाय बर्थ. फाइन. सो हमारा कोई कॉन्ट्रैक्ट से हमारा संबंध नहीं है. हमारा जो संबंध है वो स्टेटस से है, क्योंकि मैं मेरे फादर का बेटा हूँ, देयरफॉर आई एम देयर. फाइन. क्योंकि मैं अपने अंकल का नेव्यू हूँ, इसलिए मैं वहाँ पे हूँ. मेरा भाई वहाँ पे है, हम लोग कजिन्स हैं. फाइन. सो दैट इज द स्टेटस, not a contract. Fine. Therefore, Hindu undivided family and partnership firm, ये दोनों partners, ये दोनों persons नहीं कहलाएंगे. Partnership firm in another firm. These cannot be, यहाँ लिख देता हूँ कहीं पे आपकी याद रहने के लिए, यहाँ लिख रहा हूँ. These cannot be partners. Done. समझ में आया? So, partnership is a relation between persons who have come together, who have agreed to carry on any business and to share the profits and bear losses of that business. Fine. One partner can act on behalf of another partner because every partner is the agent of each other and every partner is the principal of each other. So one partner can act on behalf of other partner, or all the partners can act mutually, or one partner with the assent of all other partners can act for the benefit of the firm. This is all about partnership as mentioned in the section 4, the first paragraph. Now, the following next paragraphs are nothing but it states that persons who have entered into partnership with one another are called individually partners. Those persons are called individually partners. Collectively, all the partners, partner 1 plus partner 2 plus partner 3, जो भी हैं, they are collectively called a firm, and जो उनके फर्म को एक नाम दिया गया है जिसके अम्ब्रेला के अंदर वो काम कर रहे हैं, the name under which their business is carried on is called the firm name. Fine. This is all about partnership. पार्टनरशिप आपका यहाँ पे मेन प्रोविजन खत्म हो गया. पार्टनरशिप पूरा whole partnership got over. Now the ancillary provisions of this partnership act we shall be looking into. Fine. अब जो भी आप आगे पढ़ेंगे it will emanate from here only. Fine. This and this. Fine. पार्टनरशिप याद रखना सेक्शन 5 पूछता है प्री में, और ये पूछेंगे पार्टनरशिप इज क्रिएटेड बाय स्टेटस, बाय कॉन्ट्रैक्ट, बाय एग्रीमेंट, जो भी है. ठीक है. Partner, the relation of partnership arises from contract and not from status. And therefore, in particular, therefore the members of a Hindu undivided family carrying on a family business as such, or a Burmese Buddhist husband and wife carrying on business as such, are not partners in that business. ठीक है, फाइन. देखो, मान लो हस्बैंड वाइफ भी हैं, तो उनका रिलेशनशिप कैसे अराइज हुआ? बाय स्टेटस. कॉन्ट्रैक्ट थोड़ी ही है. हाँ, अब अगर आप मुस्लिम लॉ की बात करोगे तो उसमें जो निकाह होता है, दैट इज ऑल्सो नॉट प्योरली अ कॉन्ट्रैक्ट, दैट इज नेवर प्योरली अ कॉन्ट्रैक्ट. फाइन. तो कॉन्ट्रैक्ट तो है ही नहीं ना शादी. ठीक है, वो भी तो स्टेटस से ही अराइज हो रहा है ना. ठीक है, मान लो कोई ऐसा अगर कॉन्सेप्चुअल क्वेश्चन आ गया, आता तो नहीं है, अगर कुछ ऐसा आ गया कि ए एंड बी आर मोहम्मडन्स, husband and wife, and they have entered into a business, though the partnership act states that partnership is created by contract and not by status. And if since they are Muslims, so the business between them, which is being carried on by them, can they both be considered partner in that? Can they both be considered partner in that firm, and that whole business be called a partnership? The answer is no. No. Fine. ठीक है. Mode of determining the existence of partnership. सबसे पहले, पढ़ने से पहले लिख लीजिए केस का नाम. Do you remember the case? Section 6 का केस. Do you remember? Most celebrated judgment, Cox versus Hickman. फाइन. कॉक्स वर्सेज हिकमैन. अगर कोई केस सेक्शन 6 पे पूछा जाएगा तो यही केस पूछेंगे. फाइन. ठीक है, चलो. Mode of determining existence of partnership. In determining whether a group of persons is or is not a firm, and or whether a person is or is not a partner in a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. और जहाँ पे real relation लिखा हुआ है वहाँ पे लिखो intention. Intention. Fine. So for the purpose of considering as to whether the persons are partners in the firm or not, their intention is to be taken into consideration. Fine. अभी इंटेंशन क्यों कंसिडर किया जाएगा और कैसे किया जाएगा वो अभी आगे के क्लॉजेज में हम देखेंगे. एक्सप्लेनेशन 1 स्टेट्स दैट मियर शेयरिंग ऑफ प्रॉफिट्स. शेयरिंग है ना, यहां लिखो मियर, MERE. मियर द ओनली शेयरिंग ऑफ प्रॉफिट्स और ऑफ ग्रॉस रिटर्न्स arising from property by persons holding a joint or common interest in that property does not of itself मेक सच पर्सन्स पार्टनर्स. मान लो कोई जॉइंट प्रॉपर्टी है, वहाँ से अगर प्रॉफिट्स, सिर्फ प्रॉफिट्स वहाँ से डिराइव कर रहे हैं, वहाँ पे और कुछ काम नहीं कर रहे हैं, तो वो लोग पार्टनर्स नहीं कहलाएंगे. फॉर एग्जाम्पल, मान लो सपोज आई हैव अ फ्लैट and I am getting rent from that flat. Now I am there and my sister is there. So we two are here. Now suppose I am getting 20,000 rent, 10,000 I am keeping with myself, 10,000 I am transferring to her account. So we do not become, though we both are sharing the profits from the rent of the flat, but we do not become partners. Fine. अब जहाँ पे फ्लैट की बात आई तो वहाँ पे एक चीज़ याद रखना, एक बार क्वेश्चंस पूछा गया है, शायद दिल्ली जुडिशरी है कहीं, क्योंकि राजस्थान में तो प्रीवियस ईयर क्वेश्चंस मिलेंगे नहीं पार्टनरशिप के, तो क्वेश्चंस जो हमने सेग्रीगेट किए हैं वो वी हैव सेग्रीगेटेड फ्रॉम डिफरेंट स्टेट्स, दैट ऑल्सो वी शैल बी डूइंग हियर. एक क्वेश्चन है अलग अलग स्टेट्स के हैं, फाइन। मान लो ये डीजीएस में है, ये देन पंजाब में है, बिहार में है, फाइन। सो वी विल बी डूइंग दैट। नाउ इसमें एक क्वेश्चन है कि देयर इज एन इमूवेबल प्रॉपर्टी एंड rent is given out of that property. So whether that rent या share in that rent, something like that, whether that is movable or immovable property, fine. So भले ही the corpus है जो corpus है that is immovable property, building है, पर जो भी rent होता है, money is always movable property, shares always movable property, stocks always movable property, debenture movable property. We had seen that in the last class, आई थिंक सेल ऑफ गुड्स एक्ट में, गुड्स के बारे में जहां हम पढ़े थे, है ना, सेक्शन 2 क्लॉज 7, ठीक है, ये याद रखना। चलो एक्सप्लेनेशन 2, अगेन इंपॉर्टेंट वन, रिसीव्ड बाय अ पर्सन ऑफ अ शेयर ऑफ द प्रॉफिट्स ऑफ अ बिजनेस और ऑफ अ पेमेंट कंटिंजेंट अपॉन द अर्निंग ऑफ प्रॉफिट्स और वेरिंग विद द प्रॉफिट्स अर्नड बाय अ बिजनेस डज नॉट ऑफ इटसेल्फ मेक हिम अ पार्टनर विद द पर्सन्स कैरिंग ऑन बिजनेस, फाइन। अब सपोज वो सेम ऑलमोस्ट सिमिलर एग्जाम्पल आप ले लो, आप इस तरह से ले लो कि सपोज व्हाट आई डू, आई परचेज अ कार ज्वाइंटली विद समवन, और मैं उसको चलाने के लिए किसी और को दे देता हूँ, वहाँ से जो प्रॉफिट्स आते हैं, ठीक है, तो मैं उसके साथ पार्टनर नहीं बन जाता हूँ, फाइन। तो मियरली शेयरिंग ऑफ प्रॉफिट्स अगेन डज नॉट मेक वन पर्सन एज पार्टनर, फाइन। The intention is to be seen as to whether the business is to be carried as a partnership firm or not. If there is no business, merely sharing of profits are there, then it does not amount to a partnership firm. Correct? And in particular, the receipt of such a share or payment by a lender of money, ये भी क्वेश्चन पूछा गया है, याद रखना। ये जो 4 क्लॉजेज है ना, एकदम इंपॉर्टेंट मार्क कर लो, ये पूछा गया है। By a lender of money to persons engaged or about to engage in any business does not make him as a partner. Second one, by a servant or agent as remuneration, sharing of the receipt of such a share or payment by a servant or agent as remuneration does not make him a partner. मैं आपको एक एग्जाम्पल देता हूँ, आप ऐसे समझो। मान लो मैं एक कोचिंग क्लास स्टार्ट करता हूँ, फाइन। सपोज आई स्टार्ट अ कोचिंग क्लास। अब आज मैं अगर स्टार्ट कर रहा हूँ कोचिंग क्लास, तो मेरे पास इतने पैसे नहीं हैं कि मैं कोचिंग के मैनेजर को भी पैसे दूँ, टीचर को भी पैसे दूँ, और मेरे से ये पॉसिबल नहीं है कि मैं सारे सब्जेक्ट पढ़ाऊँ। तो व्हाट आई डू, मैं एक पर्सन के साथ पार्टनरशिप करता हूँ, मिस्टर एक्स के साथ मैं पार्टनरशिप करता हूँ कि वी बोथ विल बी रनिंग दिस कोचिंग एंड फॉर दैट पर्पस वी अपॉइंट अ मैनेजर, ठीक है। मैनेजर को हम लोग 10,000 रुपये महीने देते हैं, और उस मैनेजर को ये भी बोलते हैं कि जितने बच्चे आएंगे, अगर तुम बच्चे ला रहे हो तो उसमें से हम तुम्हें 10% देंगे, 10%, या तुम नहीं भी ला रहे हो, कहीं से भी बच्चे आ रहे हैं, तो वी शैल बी गिविंग यू 10% आउट ऑफ द फी ऑफ द स्टूडेंट, फाइन। नाउ दो आई एम शेयरिंग द प्रॉफिट ऑफ माई बिजनेस with my manager, yet that manager does not become a partner with me, fine. By the widow or child of a deceased partner as annuity. अब देखो बहुत बार क्या होता है ना कि मान लो एक पार्टनरशिप फर्म है, उसमें 5 पार्टनर्स हैं, उसमें एक पार्टनर की डेथ हो जाती है, तो देयर इज अ कॉन्ट्रैक्ट बिटवीन ऑल द अदर पार्टनर्स कि जो डिसीज्ड पार्टनर के बिलोंगिंग्स होंगे, एसेट्स होंगे उस फर्म में, वो भी तो यूज किए जा रहे हैं ना, तो उससे जो प्रॉफिट आएगा वो उस डिसीज्ड पार्टनर की विडो को दे दिया जाए या उनके बच्चे को दे दिया जाए, जो प्रॉफिट्स आएंगे, ठीक है। तो मियरली बाई शेयरिंग द प्रॉफिट्स with that widow of that partnership of that partner of that deceased partner does not make that widow as partner in the firm. क्योंकि अगर, फिर समझो, अगर मियर शेयरिंग ऑफ प्रॉफिट से पार्टनर बनता तो यहां पे भी ये लोग पार्टनर हो जाते, फाइन। नेक्स्ट वन, बाय अ प्रीवियस ओनर और पार्ट ओनर ऑफ द बिजनेस एज कंसिडरेशन फॉर द सेल ऑफ गुडविल और शेयर देयर ऑफ, ये भी क्वेश्चन पूछा है, फाइन, अलग से ये क्वेश्चन पूछा गया है। तो नाउ कोई अगर प्रीवियस ओनर है या पार्ट ओनर है बिजनेस का और जो गुडविल को सेल कर दिया है उस फर्म में, तो उसके बाद उससे जो प्रॉफिट आती है उसमें अगर उस पार्टनर को दिया जाता है कि चलो 10 महीने तक, 1 साल तक हम प्रॉफिट से आपको भी देंगे क्योंकि आपने गुडविल अपना हमें दिया है, उसके बाद हम अलग एकदम हो जाएंगे, तो उन 10 महीने या 1 साल के लिए भी that person who has sold his goodwill to the firm, he does not become a partner, though he is taking profit in the share though he is taking profit in the business of the firm. Fine? Chalo. Does not of itself make the receiver a partner with the persons carrying on the business. कोई दिक्कत यहां तक समझ गए? Come to the next provision. Section 7. Now section 7 and 8 यहाँ पे दो तरह से पार्टनरशिप होते हैं. एक तो होता है एट विल, एक होता है पर्टिकुलर पार्टनरशिप. एट विल, विल मतलब क्या? व्हाट इज द मीनिंग ऑफ विल? आपका खुद का विश, योर इच्छा, आपकी क्या इच्छा है ना? इच्छा. फाइन, दिस इज विल, इजंट इट? तो जब आपके इच्छा से ये काम हो रहा है तो उसमें ड्यूरेशन की जरूरत तो नहीं है ना, है ना? कब तक वो पार्टनरशिप चलेगा? 10 लोग हम लोग हैं, पार्टनर बन गए हैं, तो इफ द पार्टनरशिप इज a partnership at will, at our own wish, the wish of mutual wish of all 10 of us, then there is no requirement of any particular time till which that partnership shall exist, or there is no requirement of such time at which the partnership shall dissolve. Fine? Therefore, section 7 states that where no provision is made by contract between the partners for the duration of their partnership or for determination of their partnership, the partnership is partnership at will. Duration of partnership, कितने समय तक वो पार्टनरशिप चलेगा, एंड डिटर्मिनेशन ऑफ पार्टनरशिप, कब वो पार्टनरशिप खत्म होगा. फाइन? तो दैट इज पार्टनरशिप एट विल. अनदर पार्टनरशिप वी हैव, दैट इज पर्टिकुलर पार्टनरशिप. पर्टिकुलर, व्हाट इज पर्टिकुलर? पर्टिकुलर इज फॉर सम स्पेसिफिक. पर्टिकुलर क्या है? स्पेसिफिक है ना, स्पेसिफिक पर्पस. फाइन? कोई पर्टिकुलर पर्पस, कोई स्पेसिफिक पर्पस. पर्सन में बिकम अ पार्टनर विथ अनदर पर्सन इन पर्टिकुलर एडवेंचर्स और अंडरटेकिंग्स. अब मुझे कॉन्ट्रैक्ट मिलता है, मुझे कॉन्ट्रैक्ट मिलता है मान लो कोई घर बनाने का. फाइन, आई एम अ कॉन्ट्रैक्टर, I get a contract to get a house constructed. Fine. Now I feel, और मुझे 1 साल का समय दिया जाता है, तो मुझे लगता है कि मेरे से अकेले मैं और मेरे लेबर्स मिलके नहीं कर पाएंगे. I engage another contractor with me to do that business. फाइन, मुझे अगर 1 लाख रुपया उस घर बनाने के लिए मिल रहा है तो मैं उसके साथ 50,000 दे दूंगा, वो तो मेरा खुद का डिस्क्रिप्शन है ना. तो फॉर दैट पर्टिकुलर घर बनाना. फाइन. So that is that particular adventure or undertaking. Fine. So it is called particular partnership for that particular purpose. Fine. 7 और 8 याद रखना, ये sections के नंबर भी पूछते हैं. Now come to general duties of partners. Again take a 10 seconds break पानी के लिए. From yesterday we have started this. 10 सेकेंड का ब्रेक हम ले रहे हैं पानी पीने के लिए. फाइन, इसलिए कीप वाटर विथ यू. 10 सेकेंड में आप जाके नहीं ला पाओगे. Done. Now come to section 9. Section 9. General duties of partners. Partners are bound, are duty bound. देखो, I keep on writing the words in the Bare Act to make the language more easy. Fine, क्योंकि लॉ का लैंग्वेज थोड़ा डिफिकल्ट तो होता है, तो बीच में जब ये वर्ड्स लिख देता हूँ तो वो फिर पूरा सेंटेंस ईजी हो जाता है, तो यू मे अंडरस्टैंड इट मोर ईजिली. फाइन. Partners are duty bound to carry on the business of the firm to the greatest common advantage. First one, greatest common advantage of the firm. To be just and faithful to each other. Just and faithful. Second duty. Render true accounts. Third duty. Full information of all the things affecting the firm to any partner or his legal representative. Fourth duty. Fine. So there are 4 duties which generally the partners shall adhere to. Fine. And section 10 states one specific duty in relation to fraud, that every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of business of the firm. If any partner has personally committed any fraud, then he needs to indemnify the firm, means he needs to indemnify the partners of the firm. Fine. Firm is what? Firm is the collection of partners. Fine. So if one has to indemnify the firm, it means one has to indemnify the partners. As far as fraud is concerned, come to, ये तो सेक्शन 10 हुआ. Come to section 13 clause E. Section 13 clause E. Fine. And clause F. देखो एक बार यहां मैं लिख रहा हूं पहले. सेक्शन 10 आप पढ़ रहे थे. यू विल रीड इट विथ सेक्शन 13 clause E and F, and you will again read all with section 52. ठीक है. फ्रॉड है, विलफुल नेग्लेक्ट है, और फिर आगे फ्रॉड है. ठीक है. 10 to be read with 13 clause E and F read with 52. देखो, यू नेवर नो, राजस्थान में तो एंटिसिपेटेड नहीं है कि इतने इंटरलिंकिंग वाले क्वेश्चन पूछेंगे, लेकिन मान लो अगर पूछ लिए गए तो कीप योर सेल्फ प्रिपेयर्ड. फाइन. कम टू सेक्शन 13. Clause E. Subject to contract between the partners, the firm shall indemnify a partner in respect of payments made and liabilities incurred by him in ordinary and proper conduct of business, and in doing such act in an emergency for the purpose of protecting the firm from loss as a man of ordinary prudence under similar circumstances. 10 में था, we had in 10 that partner shall indemnify the firm. यही था ना? थर्टीन के ई में है फर्म टू इंडेमनीफाई द पार्टनर. करेक्ट ना? करेक्ट. कम टू 13F, clause F. A partner shall indemnify the firm for any loss caused to it by his willful neglect in the conduct of business. 13 clause F में है partner to indemnify the firm for his willful neglect. Fine. Or firm to indemnify, partner to indemnify the firm for his fraud. Correct? Correct? Write it, please write it very quickly. Section 10, partner to indemnify the firm for his fraud. Section 13, clause E, firm to indemnify the partner for the losses which he has incurred in the ordinary course of business, or in the case of emergency, the act which he has done and the amount which he has incurred as a man of ordinary prudence. Fine. And section 13, clause F, partner to indemnify the firm for his willful neglect. Fine. Come to 52 once. (52) states where a contract creating partnership is rescinded on ground of fraud or misrepresentation of any of the parties thereto, party entitled to rescind is, without prejudice to the other right, entitled to a lien or right of retention on the surplus asset and all, to rank as creditor, to be indemnified by partner or partners guilty of fraud or misrepresentation against all debts of the firm. This provision 52 states that the contract, the main document by which the partnership came into existence, when that contract is rescinded, is kept aside due to fraud or misrepresentation of any party to that contract. So 52 states that the contract is rescinded due to fraud or misrepresentation by any party to such contract. Fine. ठीक है? So this is what 52 states. So that party who has committed fraud or misrepresentation, he needs to he needs to indemnify the other parties to the contract. फाइन. ठीक है, वापस आ जाओ. अब सेक्शन 10 वापस आ जाओ. duty to indemnify for loss caused by fraud. Fine. Come to 11. Determination of rights and duties of partners by contract between the partners, agreement in restraint of trade. This section, इसमें जो second clause है, that is an exception to section 27 of the Indian Contract Act. Fine. Firstly, clause 1 states that subject to provisions of this Partnership Act, mutual rights and duties of the partners of a firm may be determined by contract between the partners, and such contract may be expressed or implied in the course of dealing. This is an extension of which section? बताओ. This is an extension of which section? 5. Partnership arises by contract, and यहाँ पर भी mutual rights and duties of the partners of a firm are determined by contract between the partners. Fine. Since partnership has arisen due to contract, therefore mutual rights and liabilities are fixed by contract between the partners. Correct? Such contract may be varied by consent of all the partners, and such consent may be expressed or implied. No issue in this. Fine. Clause 2 में आओ. Section 11 clause 2. In spite of anything contained in section 27 of the Indian Contract Act, क्या है? What is 27? फिर से बताओ. Tell again. Correct. Contract in restraint of trade नहीं है. Agreement in restraint of trade. 27 is agreement in restraint of trade. In spite of, notwithstanding means in spite of anything contained in section 27 of the Indian Contract Act, such contracts between partners for a partnership firm may provide that a partner shall not carry on any business other than that of the firm while he is a partner. The partner shall not carry any business because there are two reasons for this. First one, he may be carrying any business which is similar to the business of the firm. Fine. Similar to business of firm. अब ऐसा अगर होता है तो जो फर्म के क्लाइंट्स हैं वो तो खुद के पास ले जाएगा ना, तो फर्म को कहाँ से फायदा होगा, है ना. दूसरा रीजन ये है कि पार्टनरशिप फर्म, द पर्पस ऑफ पार्टनरशिप फर्म इज दैट द पार्टनर्स shall act in the firm as their own business. They shall be infusing all their energy in that very firm. फाइन. तो उनका खुद का फर्म है ना, 10 लोग मिलकर पार्टनरशिप फर्म चला रहे हैं, तो 10 को इक्वल प्रॉफिट मिल रहा है ना. अभी आप एक अलग से फर्म ओपन करके फर्म इस्टेब्लिश करके चले जाते हो, यहाँ भी काम कर रहे हो वहाँ भी काम कर रहे हो, तो एक ह्यूमन बीइंग कितने जगह काम कर सकता है, एनर्जी तो डिवाइड होगा ना. तो यहाँ पे तो लॉस होते चला गया ना, है ना. तो मान लो आपको पढ़ाई करनी है, आप एग्जाम की तैयारी कर रहे हो, अभी आप एग्जाम की तैयारी करने के साथ साथ 10 काम और भी ले लोगे, तो एनर्जी तो वहाँ से कम हो गया ना आपके पास, तो आपका तो ये पर्पस ही नहीं सॉल्व हुआ. ठीक है. तो इसीलिए सेक्शन 11 सेज दैट कोई ये जनरल रूल है कि कोई वो अपना दूसरा काम सिमिलर टू दिस बिजनेस कॉम्पिटिशन वाला काम नहीं कर सकता है, या ऐसे भी कोई दूसरा काम नहीं कर सकता है. ठीक. जबकि 27 में था कि एग्रीमेंट इन रेस्ट्रेंट ऑफ ट्रेड, आप ट्रेड करने के लिए रेस्ट्रेंट नहीं कर सकते हैं, क्योंकि 19 क्लॉज 1 सब क्लॉज जी कॉन्स्टिट्यूशन ऑफ इंडिया में है कि एवरीवन इज फ्री टू प्रोफेस, फ्री टू डू एनी प्रोफेशन, ट्रेड और बिजनेस. फाइन. सो क्लॉज 2 इज एन एक्सेप्शन टू section 27. देखो, since in Rajasthan you have Contract Act, you have Partnership Act both, so they may ask वो लिंक करके, सब्जेक्ट लिंक करके पूछ सकते हैं, तो याद रखना ये, ठीक है। कंडक्ट ऑफ बिजनेस, देखो जहां भी लिखा रहता है सब्जेक्ट टू कॉन्ट्रैक्ट बिटवीन द पार्टनर्स, फाइन, उसके बाद जो भी क्लॉजेज लिखे हुए हैं दे आर द क्लॉजेज विच शैल बी adhered to in the act, but these clauses are dependent upon contract. Means if there is any contract to the contrary to these clauses, then that contract will prevail. Fine. इसलिए जहां भी subject to contract है, आपको मेंस के लिए एक चीज बता देता हूं कि जहां भी subject to contract लिखा हुआ है या notwithstanding anything contained in this act लिखा हुआ है, फाइन, वो हमेशा उस चीज को लिखना, भले ही आप सेम वर्ड नहीं लिखो, नॉट विथ स्टैंडिंग के बदले आप इन स्पाइट ऑफ लिख दो, फाइन, सब्जेक्ट टू कॉन्ट्रैक्ट बिटवीन द पार्टनर्स जहां है वहां लिख दो तुम कि इफ देयर इज एनी प्रीवियस कॉन्ट्रैक्ट बिटवीन द पार्टनर्स देन दैट कॉन्ट्रैक्ट शैल प्रिवेल, हाउएवर द जनरल प्रोविजंस आर दिस, बट इफ देयर इज एनी सच कॉन्ट्रैक्ट देन सच कॉन्ट्रैक्ट शैल प्रिवेल, फाइन। तो इसको स्किप मत करना, इसको स्किप किए मतलब ये तो रूल एब्सोल्यूट हो गया ABCD, जबकि ये एब्सोल्यूट तो है नहीं, ये तो सब्जेक्ट टू कॉन्ट्रैक्ट है, तो आपका आंसर गलत हो जाएगा, है ना। सब्जेक्ट टू कॉन्ट्रैक्ट बिटवीन द पार्टनर्स, एवरी पार्टनर हैज अ राइट टू टेक पार्ट इन द कंडक्ट ऑफ बिजनेस, फाइन। एवरी पार्टनर इज बाउंड टू अटेंड diligently to his duties in the conduct of business, and any difference arising as to ordinary matters connected with the business may be decided by majority of partners. 10 पार्टनर हैं, 6 और 4, फाइन, 6-4. Every partner shall have the right to express his opinion before the matter is decided. Though majority opinion prevails, but every partner has the right to give his opinion in that matter before the matter is finally decided. But no change may be made in the nature of business without the consent of all the partners. Though in taking the decisions, majority of the partners' decision will prevail, but if the nature of the business is to be changed, then each and every partner needs to give his assent. Fine. If the nature of the business is to change, then assent of each and every partner shall be considered. Fine. The last one, every partner has a right to have access to and to inspect and copy any of the books of firms, books of accounts, of the firm. फाइन, ये तो सेक्शन 12 था, बिजनेस कैसे चलेगा, फाइन। 13 है कि इस बिजनेस को चलाने के लिए क्या क्या म्यूचुअल राइट्स एंड लायबिलिटीज होंगे पार्टनर्स के, करेक्ट। सो सेक्शन 13 states that mutual rights and liabilities, mutual rights and duties of the partners are again subject to contract between them. Fine. Partner is not entitled to receive remuneration for taking part in the conduct of the business. However, कुछ अगर ऐसे अरेंजमेंट्स किए गए हैं कि जो पार्टनर्स हैं उन्हें प्रॉफिट शेयरिंग तो मिलेगी। अब मान लो कुछ ऐसा अरेंजमेंट है कि सपोज 100 रुपीज़ का प्रॉफिट होता है, तो उसमें प्रॉफिट शेयरिंग होगा 80 रुपीज़ का, और जो 20 रुपीज़ है उससे सबको रेम्यूनरेशन मिलेगा, 4 पार्टनर्स को 5 रुपीज़। फाइन, दैट इज ओके। जनरल रूल इज दैट कि 100 का 100 प्रॉफिट शेयरिंग होना है, पर अगर देयर इज अ कॉन्ट्रैक्ट बिटवीन द पार्टनर्स तो दे में गेट रेम्यूनरेशन ऑल्सो। ऐसा भी हो सकता है कि 2 सीनियर पार्टनर्स को रेम्यूनरेशन मिलेगा, बाकी को नहीं मिलेगा। फाइन। नेक्स्ट वन, Partners are entitled to share equally in the profits earned, shall contribute equally to the losses sustained by the firm. There is one exception to the losses, that is minor वाला concept section 30 में. Minor cannot be a part in losses. ये याद रखना. और यहां एक और चीज याद रखना, यहां पे पार्टनर्स की बात हो रही है ना, तो माइनर इज नॉट अ पार्टनर इन द फर्म. ही कैन ओनली बी एडमिटेड टू द बेनिफिट्स ऑफ पार्टनरशिप. फाइन. फॉर द पर्पस ऑफ टेकिंग द बेनिफिट्स ही इज इंडक्टेड इन द पार्टनरशिप फर्म. अगर वो रियल पार्टनर रहता सारे पार्टनर्स की तरह से, तो उसे लॉसेज भी बियर करने होते ना. तो सारे पार्टनर्स के जैसा वो तो पार्टनर है नहीं. फाइन. तो लॉसेज शैल have equal share in the profits and losses except the case of minor. उन्हें वो सिर्फ प्रॉफिट शेयर करेंगे. नेक्स्ट वन, where a partner is entitled to interest on the capital subscribed by him, such interest shall be payable out of the profits, and a partner making any payment or advance beyond the amount of capital he has agreed to subscribe entitled to an interest of 6% per annum. 6% याद रखना. Next, firm shall indemnify the partner in respect of payments made and liabilities incurred by the firm in ordinary and proper conduct of business and in case of emergency, जो अभी आप पढ़े हैं. और लास्ट वन है, partner shall indemnify the firm for any loss caused to him in the willful neglect, जो अभी आप पढ़े हैं. प्रॉपर्टी ऑफ द फर्म, सिर्फ इसमें आप ये याद रखोगे कि सेक्शन 14 डील्स विथ प्रॉपर्टी ऑफ द फर्म, है ना, और इट इंक्लूड्स गुडविल ऑफ द बिजनेस. याद रखना, सेक्शन 14 डील्स विथ प्रॉपर्टी ऑफ द फर्म, includes goodwill of the business, and 15 is application of such property of the firm, that is, it shall be held and used by the partners exclusively for the purposes of business. Fine. Section 14 पूछते हैं ये लोग, ठीक है, goodwill, whether goodwill is the property of the firm or not, और property of the firm includes such and such things. तो उसमें ये लोग लिख देंगे stock, any property originally brought into the stock of the firm, or acquired or purchased or otherwise for the firm for the purpose of course of business, or goodwill of the firm, or all of the above. ठीक है. Now, अगर कोई पार्टनर को पर्सनल प्रॉफिट होता है तो वो कैसे अप्रोप्रिएट किया जाएगा? फाइन. सेक्शन 16 अगेन स्टेट्स दैट सब्जेक्ट टू कॉन्ट्रैक्ट बिटवीन द पार्टनर्स. If a partner derives any profits for himself from any transaction of the firm or from the use of the property or business connection of the firm or the firm name, he shall account for that profit and pay it to the firm. And if a partner carries on any business of the same nature as competing with that of the firm, shall account for and pay to the firm all profits made by him in that business. अभी मान लो कि कोई एक पार्टनरशिप फर्म है जो मान लो, या मान लो ऐसा देखो कि मान लो कोई पार्टनरशिप फर्म है ना, तो उसे अपने वर्कर्स के लिए उसे अपने वर्कर्स को बोनस देने के लिए कुछ चीज खरीदनी है. मान लो एक कुछ भी मान लो ना, मान लो एक सोफा सेट खरीदना है दीपावली में बोनस देने के लिए. ठीक है, अच्छी कंपनी, बड़ी कंपनी तो देती ही है ना, फर्म्स भी अच्छे हैं तो देता है वैसा बोनस. तो मान लो सोफा खरीदना है. अभी क्या है कि 10 पार्टनर्स हैं, ठीक है, और बड़ी फर्म है, तो मान लो उसमें 40 वर्कर्स हैं, 40 वर्कर्स. अब 40 वर्कर्स के लिए सोफा खरीदना है. अब मेरी जान पहचान है यहाँ सोफे वाले के पास, तो मैं सोफे वाले के पास जाता हूँ, मैं बोलता हूँ मुझे 40 पीस सोफा चाहिए. वो बोला कि हर सोफा 10,000 रुपये का है. फाइन. तो 10,000 रुपये का सोफ़ा है, तो 40 पीस में हो गया आपका 4 लाख। फाइन। नाउ व्हाट दैट सोफ़ा वाला सेज कि मैं आपको 9,000 में दे दूंगा, 9,000 में, तो 3,60,000 हो गया। मेरे पास बच गया 40,000। अब ये तो मेरे खुद के स्किल से बचा है ना, मैं खुद का जान पहचान लगा के और 40,000 रुपये बचाया हूँ, भले ही मैं कुछ भी किया हूँ, लेकिन ये 40,000 का अकाउंट, इसका लेखा जोखा मुझे पार्टनरशिप फॉर्म में देना है, ये मैं खुद से अप्रोप्रिएट नहीं करूँगा। 10 पार्टनर्स के बीच में 4,000 ईच नीड्स टू बी डिस्ट्रीब्यूटेड। फाइन। भले ही पर्सनल प्रॉफिट है, भले ही अपने जान पहचान से है, लेकिन अगर फॉर्म के काम से आप वो प्रॉफिट ले रहे हैं तो यू नीड टू गिव इट टू द फॉर्म। फाइन। अब ऊपर आप देख रहे थे 13 एंड ऑल में म्यूचुअल राइट्स एंड ड्यूटीज एंड ऑल। 17 में है सच राइट्स एंड ड्यूटीज आफ्टर चेंज इन द फर्म, आफ्टर एक्सपायरी ऑफ टर्म ऑफ द फर्म और एडिशनल अंडरटेकिंग्स आर कैरिड आउट बाय दैट फर्म। फाइन। तो इन दैट केस अगेन सब्जेक्ट टू कॉन्ट्रैक्ट बिटवीन द पार्टनर्स, वेयर अ चेंज अकर्स in the constitution of the firm, mutual rights and duties of the partners in the reconstituted firm shall remain the same as they were immediately before the change, as far as may be. As far as may be मतलब again subject to contract, as far as possible वो सेम म्यूचुअल राइट्स एंड ऑब्लिगेशन रहेंगे जो पुराने वाले फॉर्म में थे। हाउएवर अगर कॉन्ट्रैक्ट में है कि एक पार्टनर का शेयर कम करके दूसरे का बढ़ा दिया जाएगा, तो ओके, नो इश्यूज इन दैट। वेयर अ फर्म constituted for a fixed term continues to carry on business after the expiry of that term, mutual rights and duties of the partners remain the same as they were before the expiry, so far as they may be consistent with the incidents of partnership at will. अगर मान लो एक 10 दिन के लिए एक पार्टनरशिप फॉर्म थी, अगर वो उसका ड्यूरेशन बढ़ा दिया गया और भी कॉन्ट्रैक्ट मिल गया, तो वो उसमें जो बढ़ाने के बाद जो भी म्यूचुअल राइट्स एंड ड्यूटीज होंगे उन पार्टनर्स के, जो पहले 10 दिन तक थे वही होंगे, एंड वो पार्टनरशिप एट विल से कॉन्सिस्टेंट रहेंगे, उनके अकॉर्डिंग रहेंगे। ठीक है। वेयर अ फर्म कॉन्स्टिट्यूटेड टू कैरी आउट वन और मोर एडवेंचर्स और अंडरटेकिंग्स कैरीज आउट अदर एडवेंचर्स और अंडरटेकिंग्स विच वर नॉट इन द ओरिजिनली क्रिएटेड पार्टनरशिप rights in the originally created partnerships duties, mutual rights and duties of the partners in respect of the other adventures, नए वाले adventures, new adventures or undertakings are the same as those in respect of original undertakings and adventures. Fine. नाउ रिलेशन ऑफ पार्टनर्स, अभी तक आप क्या पढ़े थे? रिलेशन, म्यूचुअल रिलेशन ऑफ पार्टनर, मतलब उन खुद के पार्टनर्स एक दूसरे के साथ क्या रिलेशन था। अभी आप पढ़ेंगे कि थर्ड पर्सन के साथ क्या रिलेशन है पार्टनर्स का। फाइन। चलो, दोज हु आर ऑनलाइन, आई होप एवरीथिंग इज ओके। अगर कोई दिक्कत है, परेशानी है, नहीं समझ में आ रहा है, तो चैट बॉक्स में लिख देना। ठीक है। partner to be agent of the firm. Chalo, again take 10 seconds water break. See, in this weather it's very difficult to just keep on speaking for a long time, so pani is very much necessary. Okay, chalo. कम बैक हो गया 10 सेकेंड। partner to be agent of the firm. Partner is the agent of the firm for the purpose of doing the business of the firm, and whatever a partner does for the firm, all other partners shall be held liable in the similar manner as that partner who has done the act will be held liable. Means every partner is the agent of the firm, every partner is the principal of the firm. Fine. And notice to one partner is notice to another partner. Fine. उसका लीगल मैक्सिम बताओ, या नोटिस टू एजेंट इज नोटिस टू प्रिंसिपल. मैंने कल भी बताया था कॉन्ट्रैक्ट के क्लास में, क्वी फेसिट पर एलियम फेसिट पर से. फाइन. implied authority as agent of the firm, वेरी इंपॉर्टेंट. ये पक्का एक क्वेश्चन इससे पूछेंगे ये लोग, एकदम याद कर लो इसको, खासकर क्लॉज 2 जो है. ठीक है. क्लॉज 1, सब्जेक्ट टू प्रोविजंस ऑफ सेक्शन 22, an act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Means act of a partner simply act of the partner binds the firm. Fine. The authority of a partner to bind the firm conferred by this section is called implied authority. It is called implied authority. ये याद रखना, यहाँ पे express authority नहीं, it is called implied authority. And such implied authority, in the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to do these 9 acts. The partner cannot submit a dispute relating to business of the firm to arbitration. एकदम याद रखना ये 9 points, एकदम याद रखना. Fine. What they do? 1 minute. ठीक है. What they do in the paper, they will give you 4 options. 4 ऑप्शन में ये 3, इनमें से 9 क्लॉजेज में से 3 ऑप्शन तो रहेंगे, एक कोई और ऑप्शन दे देंगे. तो यू नीड टू जस्ट मग अप दीज 9 ऑप्शंस. फाइन. अ पार्टनर or the implied authority of a partner does not allow him to submit a dispute relating to business of the firm to arbitration, because अगर arbitration में submit करना होता तो जब partnership firm constitute हुआ था उसी समय एक arbitration agreement होता, या तो अलग से होता. arbitration agreement can be a separate agreement or arbitration agreement can be in the contract itself. Fine. A clause in the contract itself, a paragraph in the contract itself. तो अगर वो पहले से नहीं है तो कोई भी पार्टनर किसी भी डिस्प्यूट को आर्बिट्रेशन में रेफर नहीं कर सकते हैं. दे कैनॉट ओपन अ बैंक अकाउंट ऑन बिहाफ ऑफ द फर्म in their own name. Partners cannot open the bank account in their own name. Bank account has to be opened in the name of the firm. Partner cannot compromise or relinquish any claim or portion of a claim by the firm. Partner cannot withdraw a suit or proceeding filed on behalf of the firm. Partner cannot admit any liability in a suit or proceeding against the firm. Fine. Partner cannot acquire immovable property on behalf of the firm. He cannot transfer immovable property belonging to the firm. Cannot enter into a partnership on behalf of the firm. ये तो आप अभी पहले भी देखे थे कि पार्टनरशिप में क्यों नहीं इंटर कर सकता है, क्योंकि जो पार्टनर्स हैं वो तो एक फर्म है कलेक्टिवली, तो एक पार्टनरशिप फर्म तो लीगल एंटिटी नहीं है ना, तो इसलिए वो किसी दूसरे पार्टनरशिप फर्म के साथ एंटर नहीं कर सकता है पार्टनरशिप में. करेक्ट. एंड जो 19 है इम्प्लॉयड अथॉरिटी, उसका एक्सटेंशन या रेस्ट्रिक्शन क्या है? तो पार्टनर्स इन अ फर्म may by contract between the partners extend or restrict the implied authority, means these authorities are not exhaustive strictly. Fine, because the partners in a firm may by contract between the partners extend or restrict the implied authority, ऊपर में जो implied authority है, of any partner, and in spite of notwithstanding any such restriction, any act done by a partner on behalf of the firm which falls within his implied authority binds the firm unless the person with whom he is dealing knows one of the restriction or does not know or believe that partner to be a partner. मतलब generally जो भी implied authority है that will bind the firm. Fine, that will bind the firm. Now 21 states, 21 का कैप्शन याद रखना, पार्टनर्स अथॉरिटी इन इमरजेंसी. ये पूछते हैं कि 21 क्या किस चीज़ से डील करता है. वो पार्टनर जो भी है वो इन द केस ऑफ इमरजेंसी ही कैन डू एनी सच थिंग विच एन ऑर्डिनरी मैन ऑफ प्रूडेंस shall be doing for protecting the rights and for protecting the rights of the firm. Fine. Mode of doing the act to bind the firm. Now how the act of the partner binds the firm? An act or instrument done or executed by a partner or other person on behalf of the firm shall be done or executed in the name of the firm, in the firm name, or in any other manner which implies an intention of the partner to bind the firm. Fine. This section this section 22 just states that the act of the partner binds the firm and there shall be an intention of that partner to bind the firm. Effect of admission by a partner. Any admission of any fact, admission of 23 में लिख लो, admission of fact. Any admission or representation made by a partner concerning the affairs of the firm is evidence against the firm if it is made in the ordinary course of business. Any fact which the partner admits, it acts as evidence of the firm, because anything which a partner says, he says on behalf of the firm. Fine. So if he says anything on behalf of the firm, it will be considered as an evidence against the firm. If 24 देख लेना, effect of notice है, ये सब पूछता नहीं है कभी. Liability of partner, इसमें एक चीज बस याद रखना, every partner is jointly and severally liable. ये क्या होता है joint and several liability? Any idea? 25 states that every partner is liable jointly with all the other partners and also severally for all acts of the firm done while he is a partner. Jointly and severally क्या होता है? लॉ ऑफ टॉर्ट्स में पढ़े होगे आप. Those who are online, write in the chat box. What is this joint and several liability? देखो, मान लो कोई एक पर्सन है, वो पार्टनरशिप फर्म को बिजनेस करने के लिए 1000 रुपीज क्रेडिट दिया. फाइन. और पार्टनरशिप फर्म consists of two partners A and B. This person, this creditor, can either sue A for 1000 rupees or sue B for 1000 rupees or sue both jointly for 1000 rupees. If that creditor, suppose he sues A alone for 1000 rupees, then this A needs to pay 1000 to the creditor and he will subsequently claim that his 500 या जो भी उनका आधा शेयर हो तो 500 from B. ठीक है, दिस इज ज्वाइंट एंड सेवरल लायबिलिटी, आइदर ज्वाइंटली साथ में और सेवरली अलग अलग. (26) देख लेना, लायबिलिटी ऑफ फर्म फॉर wrongful acts ऑफ अ पार्टनर, लायबिलिटी ऑफ फर्म फॉर मिस एप्लीकेशन ऑफ पार्टनर्स, ये सब 27 भी देख लेना. 28 आ जाओ. देखो जो प्रोविजन मैं छोड़ता हूँ ना, यू डू नॉट लीव द प्रोविजंस बिकॉज वी हैव गॉट लिमिटेड टाइम टू कंप्लीट द सब्जेक्ट. देयरफॉर इट इज नॉट पॉसिबल टू गो इन डेप्थ इन ईच एंड एवरी प्रोविजन. फाइन, बट या वॉट एवर प्रोविजंस आर इम्पॉर्टेंट, दोज प्रोविजंस वी नेवर लीव. फाइन. होल्डिंग आउट, व्हाट इज दिस होल्डिंग? पहले तो याद रखना कि सेक्शन 28 में होल्डिंग आउट है, एकदम रट लो. फाइन. व्हाट इज दिस होल्डिंग आउट? सबसे जरूरी एलिमेंट इन दिस होल्डिंग आउट इज नॉलेज. कोई पर्सन किसी फर्म के साथ एंटर करता है किसी वर्क, किसी असाइनमेंट के लिए, और उसे नॉलेज है या नॉलेज नहीं है कि कोई पार्टनर उस फर्म में पार्टनर है या नहीं है. दिस इज ऑल अबाउट होल्डिंग आउट. तो हाउ ही विल बी एक्टिंग एंड हु विल बी हेल्ड रेस्पॉन्सिबल इन केस ऑफ एनी फ्रॉड, नेग्लेक्ट एंड ऑल सच थिंग्स. फाइन. सो होल्डिंग आउट, एनीवन who by words spoken or written or by conduct represents himself or knowingly permits himself to be represented by someone else, represented by someone else, as to be a partner in a firm, is liable as a partner in the firm to anyone who has on the fate of such representation given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person giving credit. अब आप इसको easily समझो. मैं एक पर्सन हूँ, फाइन, और सोसाइटी में मेरी अच्छी वैल्यू है, people have trust on me. Fine. कोई एक person, to any person, one representation has reached that I am a partner in some firm. Fine. अब that person, he is ready to invest some amount in that firm. और उसे लगता है कि फॉर्म में पैसे फंस तो नहीं जाएंगे देने से, तो वो देखता है कि अच्छा यहाँ पे मैं वहाँ पे पार्टनर हूँ, तो वो बोलता है कि ठीक है, मैं तो पैसे मेरे फंसेंगे नहीं, तो वो पैसे दे देता है उस फर्म में, ये जानते हुए कि मैं पार्टनर हूँ. फाइन. अब इफ ही डज सो, देन आई विल बी लायबल एज अ पार्टनर इन दैट फर्म टू दैट पर्सन, टू द क्रेडिटर. फाइन. मीन्स, और मेरी रिप्रेजेंटेशन है, वो मुझे पता हो या ना पता हो कि उस पर्सन तक पहुंची है कि नहीं जो क्रेडिट दिया हुआ है, that does not matter. Fine. On my representation he has acted, so he shall not suffer any detriment. You try to remember law of estoppel, Indian Evidence Act, Bharatiya Sakshi Adhiniyam. Estoppel, one person by believing someone else altered his position, so now it will be detrimental for him to go back to the original position. Fine. So law of estoppel, holding out, is basically based on law of estoppel. Fine. where after a partner's death, the business is continued in the old firm name, continued use of the name of the deceased partner's name as a part thereof shall not itself make his legal representatives or his estate liable for any act of the firm done after his death. Because generally when a person dies, notice is given to everyone who deals with the firm. Fine. So after a person's death, neither his legal representatives nor his estates shall be held liable for the acts, for his previous acts, to any other person. Correct? Rights of transferee of a partner's interest पढ़ लेना इसको. Minors admitted to the benefits of partnership. Minors admitted to the benefits of partnership. Read the provision once. A person who is a minor, according to the law to which he is subject, may not be a partner in the firm. एकदम first sentence है. He may not be a partner in the firm because. Reason बताओ. रीजन बताओ. कोई पर्सन, कोई माइनर पार्टनरशिप फर्म में पार्टनर क्यों नहीं हो सकता है? माइनर के साथ हम कॉन्ट्रैक्ट में एंटर नहीं कर सकते हैं बिकॉज एग्रीमेंट विथ अ माइनर इज वॉइड. फाइन. देयरफॉर सिंस पार्टनरशिप इज अ कॉन्ट्रैक्ट, देयरफॉर माइनर कैनॉट बी अ पार्टनर इन द फर्म. हाउएवर, with the consent of all the partners, not majority, with the consent of all the partners, for the time being, that minor may be admitted to the benefits of partnership, to the or for the sharing of profits of partnership. Correct? Such minor has a right to such share of property and of the profits of the firm as may be agreed upon between all the partners, and he may have access to and inspect and copy any of the accounts of the firm. ये एकदम याद करो, ये क्वेश्चन पूछे हुए हैं पहले. द माइनर दो ही विल नॉट बी अ पार्टनर. देखो जनरल रूल क्या है कि एनी पर्सन हु इज अ पार्टनर हैज द राइट टू इंस्पेक्ट द कॉपी ऑफ द फर्म. फाइन. और अकाउंट कॉपी ऑफ अकाउंट्स ऑफ द फर्म. बट अ माइनर, though he is not a partner in the firm, but he has got a prerogative, he has got a right to inspect the copy of the firm, copy of accounts of the firm. क्योंकि the reason is that the purpose of admitting that minor was for the benefit of the firm. अब अगर मान लो फर्म में बेनिफिट हुआ है 100 रुपए का और 4 पार्टनर्स हैं और 1 माइनर है, 5 लोग हैं, तो इक्वल शेयरिंग होनी है ना. सब्जेक्ट टू कॉन्ट्रैक्ट इक्वल शेयरिंग होनी है. तो इक्वल शेयरिंग में दिस माइनर शैल बी गेटिंग 20 रुपीज. अब इस माइनर को अगर 10 ही रुपया मिल रहा है तो व्हाट लीगल रिसोर्स विल ही हैव? तो द ओनली रिकोर्स ही हैज इज टू इंस्पेक्ट द कॉपी ऑफ अकाउंट्स ऑफ द फर्म. फाइन. देयरफॉर दिस एडिशनल राइट is given to such minor, though he is not a partner of the firm in the firm. He has merely entered into the firm for taking the benefits of the firm, for profit sharing. Still he has got that prerogative of inspecting the copy of the firm. एकदम अब तो भूलोगे नहीं, है ना. Such minor share is liable for the acts of the firm, but the minor is not personally liable for any such act. Means minor is not liable for any such act of the firm, and if there is any loss, then minor will not be held personally liable for that loss. बाकी तो पार्टनर्स पर्सनली लायबल होंगे ना, पर माइनर विल नॉट बी हेल्ड लायबल. प्रॉफिट मिलेगा, लॉस नहीं, लॉस के लिए नहीं लायबल होंगे. सच माइनर may not sue the partners on account or payment of his share of property or profits of the firm, save where severing his connection with the firm. Means general rule है कि such minor will not sue the partners for the accounts or payments in his share, but when he is leaving the firm, save when severing his connection with the firm, and in such case the amount of his share shall be determined by a valuation made as far as possible in accordance with the rules made in section 48. वहाँ पे जो शेयरिंग का प्रॉफिट शेयरिंग का रूल है उसके अकॉर्डिंग ही विल गेट हिज प्रॉफिट. करेक्ट. However, provided that, however, all the partners acting together or any partner entitled to dissolve the firm upon notice to other partners may elect in such a suit to dissolve the firm, and thereupon the court shall proceed with the suit as one for dissolution and for settling accounts between the partners. Amount of share of the minor shall be determined along with share of the partners. Means जब dissolution होगा तो जो बाकी partners के share होंगे वो this minor will also be getting. Correct. And within any time. Now when will this minor ratify that he wishes to continue in this firm? So at any time within 6 months of his attaining majority, पहला clause, or of his obtaining knowledge that he had been admitted to the benefits of partnership, दूसरा clause, whichever date is later. अब एकदम याद रखना, whichever date is later. मान लो एक माइनर है, एक माइनर था, वो 10th मार्च 2025 को he was admitted to the benefits of partnership. Minor. Fine. 11th जून को वो हो गया मेजर. ठीक है. 10th मार्च 2025 को वो माइनर था, 11th जून 2025 को वो मेजर हो गया. फाइन. इस समय ये एडमिटेड टू द बेनिफिट्स ऑफ पार्टनरशिप था, अभी भी एडमिटेड है टू द बेनिफिट्स ऑफ पार्टनरशिप. फाइन. बट this person does not know on 11 June that he has been admitted to the benefits of partnership. However, आज what is the date? 4th July. On 4th July, he comes to know that yeah, he is admitted to the benefits of partnership और section 30 लगेगा. फाइन. पार्टनरशिप एक्ट का. तो आज से 6 मंथ के अंदर, मतलब जुलाई, अगस्त, सितंबर, अक्टूबर, नवंबर, दिसंबर, जनवरी, 3rd जनवरी 2026 तक he has the right to either inform the partnership, partners that he will continue to be the partner, or he wishes to leave the firm. उसकी मेजॉरिटी 11 जून से काउंट तभी होती अगर उसे पता चलता रहता 11 जून को कि वो ही हैज बीन एडमिटेड फॉर द बेनिफिट्स ऑफ पार्टनरशिप. उसे पता नहीं था, इसलिए नाउ जब उसे पता चला तो उस दिन से 4th जुलाई से काउंट होगी. ठीक है. विच एवर डेट इज लेटर, एकदम याद रखना. सच अब व्हाट विल हैपन इफ ही विशेज टू कंटिन्यू और डिसकंटिन्यू. ही शैल गिव a notice, he shall give a public notice he shall give a public notice that he has elected to become or that he has elected not to become a partner in the firm, and such notice shall determine his position as regards the firm. His position means whether he will continue to be the partner or he wants to discontinue himself as a partner. Provided that, however, if he fails to give such notice, he shall become a partner in the firm on the expiry of the said 6 months. अब ये said 6 months आपके केस में काउंट होगा 4 जुलाई से. अगर आपको पहले पता होता तो फिर 1 जून से ही हो जाता, 11 जून से ही हो जाता, है ना. Where any person has been admitted as a minor to the benefits of partnership in a firm, burden of proving the fact that such person did not have the knowledge of such admission. मैं थोड़ा वर्ड्स को सेंटेंस चेंज करके पढ़ रहा हूँ, तो इसलिए उसके लिए चिंता मत करना. जो बैरक में लिखा है और मैं भी वही चीज़ बोल रहा हूँ, दूसरे लैंग्वेज में बोल रहा हूँ, ठीक है. द बर्डन ऑफ प्रूविंग द फैक्ट दैट सच पर्सन डिड नॉट हैव द नॉलेज ऑफ सच एडमिशन अंडर अ पर्टिकुलर डेट until a particular date after the expiry of 6 months of his attaining majority shall lie on the persons asserting the fact. And who will be asserting the fact? This minor will be asserting the fact. So this burden of proof will be on the minor. अभी आपसे अगर पूछा जाएगा कि बर्डन ऑफ प्रूफ के बारे में कौन से प्रोविजन में दिया हुआ है सेक्शन 30 के सब क्लॉज में, तो क्लॉज 6 डील्स विद द बर्डन ऑफ प्रूफ. सेक्शन 30 क्लॉज 6. इसलिए बेयर एक्ट में ऑलवेज ट्राई टू रीड बिटवीन द लाइन्स. Where such person becomes a partner, his rights and liabilities as a minor continue up to the date on which he becomes a partner, but he also becomes personally liable to third parties for all acts of the firm done since he was admitted to the benefits of partnership, and his share in the property and profits of the firm shall be shared to which he was entitled as a minor. And if he elects not to become a partner, then his rights and liabilities shall continue to be those as they were since he was a minor, and his share shall not be liable for any acts of the firm after the date of such notice that he wishes to leave the firm, and he shall be entitled to sue the partners for his share of the property profits in accordance with section 4. जब वो फॉर्म छोड़ रहे हैं तो उसके बाद वो he can sue, and nothing in section 7 and 8 shall affect the provisions of holding out under section 28. Fine. Now come to incoming and outgoing partners. Fine. Let's again take a 15 seconds break. पानी पी लो. Now the provisions that we have, ये सब provisions बहुत समझने वाले नहीं हैं. जो समझने वाले provision थे वो 30 तक खत्म हो गया. अब बेयर एक्ट है जो भी है, मतलब बेयर एक्ट रीडिंग है, वो प्री में भी जब पूछेंगे तो दे में आस्क कि रिटायरमेंट ऑफ पार्टनर कौन से सेक्शन में दिया हुआ है एंड ऑल. ठीक है, चलो. Introduction of a partner, section 31. Subject to contract between the partners under the provisions of section 30, no person shall be introduced as a partner into a firm without the consent of all the existing partners, and subject to provisions of section 30, person who is introduced as a partner in the firm does not thereby become liable for any act of the firm done before he became a partner. क्योंकि 30 में ये दिया हुआ था ना कि if he elects, section clause 7 अगर आप याद करो, if he elects to become a partner, clause 7 आप याद करो, if he elects to, where such person becomes a partner, his rights and liabilities as a minor continue to the date on which he becomes a partner. मान लो आपके केस में जब से उन्हें जब वो पार्टनर बना, इफ ही इलेक्ट्स टू बिकम अ पार्टनर 4 जुलाई को, जिस दिन उसे पता चला उसे, ठीक है, बट he also becomes personally liable to third parties for all the acts of the firm done since he was admitted to the benefits of the partnership when he was a minor. ठीक है, इसीलिए यहां पे बोल रहा है 31 के क्लॉज 2 में, subject to provisions of 30, person who is introduced as a partner in a firm does not thereby become liable to any act of the firm before he became a partner, subject to section 30. Means section 30 clause 7 will prevail. Section 30 clause 7 will prevail. Fine. Retirement of the partner. A partner can retire with the consent of all the other partners or in accordance with express agreements by the partners, and in the case of partnership at will, by giving notice in writing of all the other partners of his intention to retire. ये याद रखना, section 7 was partnership at will, if I am not wrong. It has to be read with section 30, section 32, clause C. Fine. Retiring partner may be discharged from any liability for the acts of his firm, from the acts of the firm. A retiring partner may be discharged from any liability to any third party for the acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm after the retirement of that partner, and such agreement may be implied by a course of dealing between the third party and reconstituted firm after he had knowledge of the retirement. And in spite of retirement of a partner from a firm, he and the partners continue to be liable as partners to third persons for any act done by any of them which would have been an act of the firm. If done before his retirement, that person will be held liable until public notice is given of his retirement, provided that a retired partner is not liable to any third party who deals with the firm without knowing that he was a partner. अभी मान लो कोई स्लीपिंग पार्टनर है, तो वो रिटायर हुआ, तो थर्ड पार्टी को तो ऐसे भी नहीं पता है कि वो पार्टनर था, तो उससे उसके रिटायरमेंट होने से उसके राइट्स पे तो कोई फर्क नहीं पड़ रहा है ना, तो इट विल नॉट अफेक्ट हिम. एंड नोटिसेज अंडर सेक्शन 3 में बी गिवन बाय रिटायर्ड पार्टनर और एनी पार्टनर्स ऑफ द रिकॉन्स्टिट्यूटेड फर्म. रिटायरमेंट इज समथिंग डिफरेंट 32 में, एक्सपल्शन इज समथिंग डिफरेंट 33 में, याद रखना. Expulsion can be, a partner may not be expelled from any firm by any majority of the partners save in exercise in good faith of powers conferred by contract between the partners. Means generally other partners cannot expel a partner, but अगर contract में है ऐसा होने का तो they can do. And provisions of 2, 3, 4 of 32 retirement वाले provisions will be applying to the expelled partner as if he was a retired partner. Correct? Insolvency याद रखना, बस प्रोविजन याद रखना, सेक्शन 34. Okay. Then when a partner leaves the firm, an outgoing partner may carry on a business competing with that of the firm. ये क्वेश्चन पूछा है, ठीक है. And he may advertise such business, but subject to contract to the contrary, he may not use the firm name, represent himself as carrying on the business of the firm, solicit the custom of persons who were dealing with the firm before he ceased to be a partner. Fine. So this question has been asked, what an outgoing partner can do, what he cannot do. So he can carry on the business competing with that of the firm. He may even advertise the business, but he cannot use the old firm name. He cannot represent himself कि वो उसी firm का partner है, and he cannot solicit the custom of persons जो उस partners, जो उस firm के साथ डील कर रहे थे, ठीक है। A partner may make an agreement with his partners that on ceasing to be a partner, he will not carry on the business similar to that of the firm within a specified period or within specified local limits, and in spite of anything contained in 27 of Contract Act, such agreement shall be valid if the restrictions imposed are reasonable. मतलब वो कर सकता है कि चलो अगले 1 साल तक मैं सिमिलर बिजनेस नहीं करूँगा, और या अगले 5 साल तक मैं उस एरिया में बिजनेस नहीं करूँगा जहाँ पे ये पुराना फर्म था, ठीक है। तो उसका बिजनेस नहीं करना, इट विल नॉट बी कंसिडर्ड टू बी एनीथिंग अगेंस्ट 27 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, क्योंकि उसके ट्रेड एंड उसके ट्रेड पे तो रेस्ट्रिक्शन लग रहा है ना, ठीक है, बट स्टिल दैट विल नॉट बी कंसिडर्ड एज एनीथिंग अगेंस्ट द इंडियन कॉन्ट्रैक्ट एक्ट। फाइन, ये देख लेना, राइट ऑफ आउटगोइंग पार्टनर इन सर्टेन cases to share the profits, revocation of continuing guarantee by change in firm। कॉन्ट्रैक्ट एक्ट में continuing guarantee कहाँ पे दिया हुआ है, याद है? 129, ठीक है। अब फर्म डिजॉल्व होता है, फर्म डिजोल्यूशन ऑफ पार्टनरशिप फर्म बिटवीन ऑल पार्टनर्स इज कॉल्ड डिजोल्यूशन ऑफ फर्म। फर्म खत्म हो गया, डिजॉल्व हो गया। नाउ डिजोल्यूशन कैन बी बाई एग्रीमेंट विद द कंसेंट ऑफ ऑल द पार्टनर्स, देयर कैन बी कंपल्सरी डिजोल्यूशन, क्योंकि सारे पार्टनर्स अगर इनसॉल्वेंट हो गए, एक बच गया, तो एक बंदा तो पार्टनरशिप फर्म नहीं चला सकता है, तो दैट इज कंपल्सरी डिजोल्यूशन। या मान लो कोई ऐसा इवेंट हुआ जो फर्म के बिजनेस को अनलॉफुल कर दिया, बिजनेस कंटिन्यू अगर होता है तो अनलॉफुल हो जाएगा, तो दैट इज कंपल्सरी डिजोल्यूशन। फाइन, or provided however where more than one separate adventure or undertaking is carried on by the firm, illegality of one business does not itself make the firm to dissolve। Fine, dissolution on happening of certain contingency, अगर किसी contingency पे based है तो firm will dissolve if that contingency occurs or does not occur। जैसे subject to contract between the partners, a firm is dissolved if constituted for a fixed term after the expiry of that term। Fine, if constituted to carry on one or more adventures, जो partnership at जो particular partnership था, by completion thereof, death of a partner and adjudication of a partner as insolvent। Fine, then dissolution by notice of partnership at will, जो partnership at will था 8(7) वाला, वो अगर नोटिस दिया जाता है कि दैट फर्म टू शैल डिजॉल्व, देन द फर्म विल डिजॉल्व। फाइन, डिजोल्यूशन बाय कोर्ट, नाउ कोर्ट कैन डिजॉल्व इन दीज सिचुएशंस, इन 7 situations, that is if the partner has become of unsound mind। Fine, या partner other than the partner suing has become in any way permanently incapable of performing his duties। There are 7 situations, इसको एक बार पढ़ लेना, ठीक है। Then liability of acts done after dissolution, ये सब कभी नहीं पूछा है। Then ये जो 48 है, मोड ऑफ सेटलिंग अकाउंट्स, यही आप माइनर में पढ़े थे ना, वंस ही लीव्स द फर्म, वो 48 के अकॉर्डिंग अकाउंट सेटल होंगे। फाइन, देन देखो एक बार 54 और 55 देख लेना, सिर्फ 54 रेस्टोरेंट ऑफ ट्रेड और 55 14 वाला गुडविल, ठीक है। एक सेकेंड, अपॉइंटमेंट ऑफ रजिस्ट्रार्स, बस सेक्शन नंबर याद कर लेना, 57 और 58 एप्लीकेशन फॉर रजिस्ट्रेशन। 59 is registration. Why is registration necessary? Any idea? हाँ, मतलब for the purpose of suing, for the purpose of filing of the suit, of any suit, fine, registration is necessary, क्योंकि a non-registered firm cannot sue, fine. So this is the purpose of registration. You come to 69. When was section 69 enforced? When was section 69 enforced? क्लास के शुरुआत में बताया हूं ना. Write in the comment box. Partnership Act was enforced on 1st October 1932. 69, section 69 came into force on 1st October 1933. Correct? These are the effects of non-registration, that is, no suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm or any person alleged to be or have been a partner in the firm, unless the firm is registered. The person suing is or has been shown in the register of firms as a partner in the firm. Fine. So this is the main purpose of registration. Again, no suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party, unless the firm is registered and the persons suing are or have been shown in the register of firms as partners in the firm. And provisions of subsections 1 and 2 shall apply to a claim of set-off or other proceeding to enforce a right arising out of a contract, but shall not affect the enforcement of any right to sue for dissolution of the firm and all. ये देख लेना. अब मुझे बस एक चीज बता दो कि ये सेट ऑफ क्या होता है, या सेट ऑफ किस सब्जेक्ट में दिया गया है, इतना बता दो बस. कोड ऑफ सिविल प्रोसीजर, सेक्शन ऑर्डर, कुछ भी, ऑर्डर 8, रूल 6A. ठीक है, सेट ऑफ, ascertained sum of money. Fine. This section shall not apply to firms or to partners in firms which have no place of business in the territory to which this act extends. What is the territory to which this act extends? To the whole of India. Or whose places of business in the said territories are situated in areas to which by notification under section 56 the chapter does not apply. section 56 में दिया हुआ है कि स्टेट गवर्नमेंट अगर चाहे तो किसी भी जगह से इस एक्ट के एप्लीकेशन को खत्म कर सकता है या इन्फोर्स नहीं करे. टू एनी सूट और क्लेम of set off not exceeding 100 rupees in value which in the presidency towns is not of a kind specified in section 19 of presidency small causes courts and all. Fine. सेवेंटीज पेनल्टी फॉर फर्निशिंग फॉल्स पर्टिकुलर्स कभी नहीं पूछता है. पावर टू मेक रूल्स, स्टेट गवर्नमेंट हैज द पावर टू मेक रूल्स. स्टेट गवर्नमेंट बस याद रखोगे. डन पब्लिक नोटिस हाउ इट इज गिवन, कभी भी नहीं पूछता है ये सब. रिपील्स एंड सेविंग्स. फाइन. ये सब देखना होगा तो देख लेना, जरूरत भी नहीं है. याद रखना 74 में सेविंग है बस, उसके अलावा कुछ भी नहीं. ठीक है. सो दिस इज that we have completed Partnership Act. I still need some time. कुछ questions हैं वो कर लेते हैं. You might be having another class ना. अनदर क्लास यू माइट बी हैविंग, नो इश्यूज, 10 मिनट में हो जाएंगे. टेक अ ब्रेक फॉर 10 seconds. पानी पी लो. Tell me whether is registration necessary or optional. यहाँ optional. Registration is optional. अगर registration नहीं होता है तो कुछ legal rights नहीं मिल पाते हैं, right to sue and all. Fine. Else registration is not mandatory, it's optional. ठीक है, चलो. Let's have a glance at the questions. First one. Who among the following is a partner? Money lender sharing the profits. He is not a partner. Person sharing the return arising from joint property. आपने पढ़ा है, नहीं है partner. मैं rent का example आपको दिया था. Seller of goodwill sharing the profits of business. ये भी आपने पढ़ा है, partner नहीं है. पर a person sharing the profits of business carried on by all or any of them is a partner. Section 4. Correct? Partnership is partnership at will. Section 7. कब? When no provision is made for determination of partnership or for duration of partnership. Correct? Now find the correct answer. The agreement, right one मैं पढ़ रहा हूँ. Agreement must necessarily provide for sharing of profit as well as लॉस ऑफ बिजनेस. फाइन. बाकी आप क्लॉजेज देखोगे ये पार्टनरशिप में नहीं फिट बैठ रहे हैं. इन ओवरऑल एनालिसिस इट अपीयर्स दैट एवरी एजेंसी इज बेस्ड ऑन म्यूचुअल पार्टनरशिप. सब नहीं है. ठीक है, नहीं इसलिए है क्योंकि मान लो एजेंसी में एजेंट है आपका, मेरा कोई एजेंट है तो मेरा पार्टनर नहीं हो गया ना, है ना. आई हैव एम्प्लॉयड हिम फॉर सम स्पेसिफिक पर्पस, ही इज नॉट माई पार्टनर. ऑन कंपेयरिंग द फंक्शन एवरी पार्टनर हैपेंस टू बी अ स्लीपिंग पार्टनर. नेवर. There must be an agreement entered into by all the persons forming partnership. ये partnership उसमें section 5, section 4 में तो एक नहीं दिया हुआ है ना. तो D is correct. Then share or interest of a partner in partnership having immovable property is, जो मैं अभी आपको बताया था वो sharing of interest, sharing of profit, sharing of पैसा, money is a movable property. ठीक है. Partnership arises by contract. In which of the following partnership does not exist? Lending of money receiving profit, lender of money receiving profits, no partnership. Servant है आपका, ये agent है, no partnership. Widow और child जो partnership deceased partner के shares जो उन्हें मिल रहे थे, they are not partners. Seller of goodwill receiving profit, he is not a partner. Partnership arises by contract. Relation of partnership arises by from contract. Ingredient of holding out, knowledge, knowledge of representation. सब वहाँ मैं लिखा भी था जब मैं पढ़ा रहा था. Fine. Not correct about a minor. देखो इसमें ना ये क्वेश्चन गलत, ये आंसर गलत है. जो पहला भी है, he cannot become a minor. He cannot become a minor. He cannot become a partner. ये भी आंसर सही है. He is personally liable for the acts of the firm. गलत है. Admitted to the benefits of partnership. सही है. Elect to become or not to become a partner or on attaining majority. ये भी सही है. ठीक है. हाँ, in fact cannot लिखा हुआ है ना, sorry. Is not correct. This is correct. He cannot become a partner. ठीक है, सही आंसर है. Which one is not correct regarding implied authority of a partner to act as agent of the firm? आपको मैं बोला था वो सारे याद करने के लिए, है ना. देखो, he has a right to sell the chattels of the firm is not correct. He has the right to sell goods or chattel of the firms, right to receive payment of debts due to the firm, right to make equitable mortgage depositing the title deeds belonging to the firm. ये सारी चीज सही है और this one right to acquire immovable property on behalf of the firm. Sorry, ये आंसर एक बार मुझे देखने दो. Which is not correct regarding. D is correct. एक बार रुकना, एक बार. इम्प्लाइड अथॉरिटी वाला क्वेश्चन है ना, इम्प्लाइड अथॉरिटी वाला क्वेश्चन है ना. हाँ, he cannot acquire immovable property on behalf of the firm. He cannot transfer immovable property on belonging to the firm. Fine, cannot do either of these things. So यहाँ पे आपका not correct. He has a right to acquire immovable property. हाँ correct. It is incorrect. सही है, ठीक है. चलो. Minor who has been admitted to the benefits of partnership. Such minor can sue the partners for access of the books of accounts. Authority to bind the firm under 19. Implied authority. Which one is implied authority? He cannot submit a dispute to arbitration. He cannot open a bank account on in his own name. He cannot compromise or relinquish any claim or portion of claim by the firm, but he can carry on the business of the firm in the usual way. A partner wants to dissolve the firm before the agreed time, which is not a perfect ground. अब देखो, that one of the partners has become permanently incapable of performing his duties as a partner, so the firm can be dissolved. That other partner has transferred the whole of his interest in the firm to a third party, firm can be dissolved then. That the business of the firm cannot be carried on except loss, firm can be dissolved. But if any partner is having any adulterous relationship with the wife of another partner, which is apprehensive to affect the business of the firm, this is not a ground to dissolve the firm. Fine. On death of a partner, in the absence of any term to the contrary, partnership is dissolved where there are only two partners and one dies, because one partner alone cannot run a partnership firm. If a partner withdraws from the firm by dissolving it, then such a dissolution is not his retirement. Fine. According to 44, court may dissolve if any partner has become insane or he has become incapable permanently, or there has been any breach of agreement. Fine. Dissolution by court, section 44. Fine. A seller partner of sale of goodwill after dissolution can exercise, he has a right to carry on business competing with that of the buyer of goodwill and may advertise such business. अभी आपने देखा है. Fine. Not a condition precedent for filing a suit under section 69. देखो, firm should be registered, correct. Person suing shall be shown as a partner in the register of firms, correct. Enforcement of a right arising from contract or conferred by this act, correct. But enforcement of any statutory right, this is not a condition precedent for suing the for a suit under section 69. Fine. Partnership situated in Delhi institutes suit for recovery of price of goods sold, supplied and delivered by the said firm to the defendant. Firm is not registered under the Indian Partnership Act, suit cannot be maintained. Fine. एक चीज और आप मुझे बताओ, यहां लिखा हुआ है द सूट इज नॉट मेंटेनेबल एंड द प्लेंट विल बी रिजेक्टेड. अंडर विच प्रोविजन अ प्लेंट इज रिजेक्टेड? ऑर्डर 7, रूल 11. फाइन. ठीक है. रिजेक्शन ऑफ प्लेंट, रिटर्न ऑफ प्लेंट, rule 10, order 7, rule 10. Fine. Provisions regarding effect of non-registration, 69. Dormant partner. A dormant partner is not interested in the business of the firm is entitled to share the profits, neither active nor known to outsider. But पूछ रहा है not correct. A dormant partner is not liable to for the firm's liability to outsiders. This one is not correct. Fine. Partnership not registered with the register of firm under Partnership Act can only file a suit based on common law rights. Fine. In this way, we complete the Partnership Act. I hope you all have understood the Act. Again, I am telling one simple thing. Do not be in a hurry in the examination hall. Read the question twice, thrice, read the options. It might be 100% that you know the answer. Fine. Means just by reading half of the question, you will come to know the answer. You might be 100% correct, but still try to remember my words. Just read the question fully, read all the options, and then choose the correct one. Fine. Best of luck. You still have other subjects remaining. That will be done in due course of time. Fine. I had to take these three subjects: Partnership Act, Indian Contract Act, and Sale of Goods Act, and that I have done. Fine. Other faculties are taking the subjects, and it will be completed in due course of time. Fine. Best of luck for your exams. Thank you.